Hello everyone, how are you? How are you all today? Sweetie, if you're Sean Diddy Collins. The court has just received fresh evidence from the prosecution that may ensure you spend up to 8 years behind bars. What am I talking about? You guys? Alright, recall how Jeff Samaranian said, "Listen, I'm tired of you all." Listen, I would want a list of examples demonstrating the average by the third. Once more, I don't trust either of you. Thus, I don't want compelling case law. I will personally read them. I have some of the greatest legal clerks and clerks in the industry. I don't require the convincing reasons from you. I don't even require you to accomplish that. All I need is that you provide me with many situations where the facts were somewhat similar and the person had no priors. Give me Mann Act cases, please. All right? It was now expected to be a joint communication from the prosecution and defense. However, the defense stated that they wished to provide their own letter in response to the prosecution's new letter. Your Honor, now, what makes this significant? For those of you who are unaware, Judge Samaranian has neither minimum nor maximum requirements. What is meant by that? They want Diddy to do his term, which is around a year. Isn't that right? Uttering, "Oh my God, nobody's ever gotten prison time for this." Nonetheless, the prosecution included a 4-page dossier with several examples of persons who, believe me, had never been in the Mann Act before receiving years in prison. All right? The defense was colored in a letter that was filed by the prosecution. The defense retaliated by claiming that all of these cases were legally binding. Oh my God, this proves something. Say some people now. However, it doesn't prove anything because the defense were quite explicit in those situations about what they were saying. The defense was shadowed by the prosecution, which claimed that they would not collaborate. We intended this to be a joint filing. So listen, Your Honor, nobody goes to jail for the many convictions, the defense said. However, there are more than 80 examples that demonstrate that many individuals do. And Diddy ought to be included on that list. It appears that the defense has a little attitude as a result, saying things like, "Oh, we'll file separately." You simply proceed with this. Diddy's teams claim that no one does real time for the Mann Act is the problem that the prosecution has just ruined. The administration stated unequivocally, and we will read the answer. Put an end to the bullshit. We are now providing you with a long list of instances that were sent to prison. All right. The judge gave me the shade when the prosecution informed me outright that Diddy's crew rejected our attempts to cooperate. It may now appear as though they are concealing the truth. They appear to be uncooperative at best. At worst, it appears like they are keeping things under wraps. Now pay attention. This is the danger. Diddy may face actual jail time rather than a celebrity smack on the wrist if the court accepts the government's argument. All right. Once more, pay attention to what the prosecution really said. They said, "The government respectfully submits this letter in response to the court's July 9th order directing the parties to provide sentencing data to the court. From this, that, and a third part. The court specifically asked the parties to provide any relevant information about sentences given in cases where the primary or single conviction was for a Mann Act violation, correct? When they answered no, prior, the basic offense level under the sentencing rules was determined using the criminal history. The court also ordered that no arguments be included in the letter and urged the parties to find cases that fit these requirements by docket number and jurisdiction. The administration has identified a number of situations that meet the requirements. They continue by listing around 80 examples, all right? They claimed that the defense counsel notified the government that they would not be able to share their case list with the government prior to filing there, and would instead be submitting their list straight to the court following discussions with the defense over a joint letter, which the judge did request. As a result, the government is presenting its arguments in this letter as opposed to a combined one. Once more, Diddy's team believes that they won't have a response to the case law if they don't give the government enough time to be ready. Now, that's interesting enough. But it seems to me that the prosecution and the judge are kind of playing in the court's face, because although they may have given 180 cases, the prosecution only seems to have given about 80 cases. And the court may have given at least 120 cases. Take a look at this disclaimer from Diddy's Tide. Second, we offer a more comprehensive list of other instances in which a primary or exclusive conviction was for breaking the Mann Act. In order to find these instances, we searched each district's PACE or criminal case report for cases under the Mann Act in the citation field, which finds dockets with a Mann Act charge. Please be aware that in these cases, it is not always possible to ascertain important details about these dockets, such as the offense conduct and how the guidelines were applied. Because of the limited information available on some dockets that differ from PACER practices across districts and the sealed nature of many filings. However, we include these situations for the purpose of completeness. In essence, you're claiming that you're citing a number of examples that aren't even really related to the points you're making on Diddy's behalf. Why include it then? Because they are listing 120 and 150 cases. Even though the government only listed 80, although there are many instances on file, they may not be pertinent. Why would they act in this way? To give the impression that all of the phony journalists, bloggers, nasty, bum-ass, low-life Diddy fans, and blogs are pleading with Diddy for a handout and payment, isn't that right? Give a shout-out to those who are already incarcerated. They're attempting to construct a story, I guess. It's when things start to get a little murky, and it appears that Diddy may have taken on more than he can handle. Let me tell you this, in the hopes that Jera Ione will be able to throw the book at Diddy, but no one knows what he will rule. Anyway, let's get started. It is untrue to say that no one is ever convicted of serious crimes without any prior convictions, and the paperwork provides real proof of it. All right? They have demonstrated that. For a split second, they have verified that. Should the judge be feeling forgiving, the minimum confirmed duration when he considers the averages is 18 months. But of all the cases that were filed, that is the safest, lowest number that is still on file. Many adult, non-child Mann Act instances with organizational and managerial components are found in the middle of the package, which lasts from 24 to 60 months. Jordan is at 60 months, whereas Briner, one of the examples mentioned, is at 30 months. In the next 6 to 10 years, it appears that the government will really implement the policies it has stated it will support. Acquire this. They appear in areas with multi-state governance, blockage, coercion, or violence, or other clusters. That instance of Hibbler at age 8 is a perfect illustration. Therefore, true jail time is stated in the government's receipts. Indeed, serving time in a real prison is rather common. The receipts match. We extracted the data from the prosecution's and government's cases. I apologize for the defense and prosecution submission. The average for the Southern District of New York is around 30 months. The Emperor's Club is that, and this was a Hollywood producer for 60 months. Due to the judge's involvement in something, Western New York slammed a judge with 18 months in prison in addition to a judgment. Additionally, a Texas case involving coercion lasted 8 years. Therefore, it is simply untrue to say that no one makes time for the madman. All right? Let's go on to the Second Circuit, which is, to be honest, the most crucial one. Well, that's when things start to get a bit complicated. 7 months is the established minimum. That is an instance of hanging urine. A typical terrible cluster lasts between 21 and 60 months. The Chin case was given 21 months. Briner was given 30 months. Green received 30 months. Jordan was given 60 months. Although there were outliers younger than 12 months. This is uncommon in the Southern District of New York due to Adult Mann Act instances in the Eastern District. As Diddy's team stated, it's his first offense. Therefore, the optimum low figure will be between 7 and 12 months. But what really gets people talking is the brutality and obstruction of justice that Diddy and his defense counsel essentially acknowledged. Even though the majority of the aforementioned incidents involve commercial shipping and do not include violence or obstruction on record, the court did decide that Diddy had engaged in obstruction of justice, and his bail was rejected. For this reason, the court has previously noted in a number of Diddy cases. That is precisely what shifts the results from the 21 to 30-month lane toward the 5-year or more lane. Jordan's 60-month sentence is a clear example of a management case that lasted 5 years in New York's Southern District despite the absence of any evidence of graphic violence. Then what should we do? According to the receipts, receiving jail time is common in New York, regardless of the duration. 21, 30 or 60 months sit is correct on the books for well-behaved adults, correct? A judge in New York's Western District was given 18 months. 7 months would be the lowest that could be verified. But violence alters the equation. The entire premise of the government's brief is that the judge has the authority to go considerably beyond the 21 to 30 months and ban period when violence and obstruction are involved, both in court and in appeal. What does this signify you? Guys, it has several meanings, but mostly it indicates that Diddy is in a profound state. Regardless of how much Brian still believes in these mitigating reasons, Judge Arun has already verified them, reprimanded him, and told him to act as though they will go away. It appears that Diddy will face consequences. We hope that both the victims and the victims of the future will receive justice. I hope they don't unite if Judge Arun fulfills his obligations. I will attempt to go live later to discuss this. But for now, listen, I'll create a follow-up video if not. However, Diddy may spend a good 5, 6, 7, or even 8 years behind bars as a result of Mark Agnelio's closing argument, which got him off. Listen, everyone, and share your thoughts with me.